Gray Mendez and Felix Herrera Garcia. On September 15, 2023, 4 toddlers collapsed inside a daycare center in the Kingsbridge Heights neighborhood of the Bronx. First responders rushed inside El Divino Niño and immediately administered Narcan, because the children weren't sick. They had been exposed to a lethal synthetic substance hidden inside the building. One of those children, Nicholas Feliz Dominici, did not survive. 3 others were rushed to the hospital in critical condition with acute poisoning. They would survive, but barely. When investigators searched the daycare, they found a trap door beneath the playroom floor. Hidden in the compartment underneath was over 11 kilograms of illicit narcotics. A 1-kilogram brick was sitting directly on top of the children's play mats. Kitchen tools where the food was prepared with doubled as drug processing equipment. 3-kilo presses and packaging supplies were scattered throughout the space. El Divino Niño wasn't just a daycare. It was a large-scale narcotics packaging and distribution hub, and the children played on top of it every single day. The daycare was operated by Gray Mendez. Her husband, Felix Herrera Garcia, ran the drug side of the operation alongside his cousin Carlisto Acevedo Brito and a man known as El Gallo, whose real name was Reni Antonio Parra Paredes. The conspiracy had been running since roughly October of 2022, nearly a full year before that fatal September afternoon. Mendez knew about all of it. She helped run the daycare while her husband and his associates processed narcotics in the same rooms where toddlers ate lunch and took naps. But here is the detail that makes this case unbearable. Weeks before Nicholas lost his life, Mendez noticed her own child showing symptoms consistent with toxic exposure. She pulled her child out of the daycare, but she did not report it. She did not warn the other families. She kept the doors open and kept collecting payments while other people's children crawled across floors saturated with one of the most lethal substances in existence. When children started going limp on September 15th, Mendez did not call 911. She called her husband first. Garcia arrived, grabbed bags of narcotics, and fled through a back alley while children lay unresponsive inside. Mendez then deleted over 20,000 text messages from her phone and lied to paramedics about what had happened. Garcia fled the country entirely, making it across the border into Mexico. He was eventually captured and extradited back to the United States. How does someone look at a room full of toddlers every morning, knowing what is hidden beneath their feet, and choose to do nothing? Both Mendez and Garcia faced charges in 2 separate courts. Federally, in the Southern District of New York, before Judge Jed S. Rakoff. They were charged with conspiracy to distribute narcotics resulting in death, along with possession with intent to distribute resulting in death and serious bodily injury. Garcia pleaded guilty in June of 2024. Mendez followed on October 29th of that same year. At the state level, in Bronx Supreme Court before Justice Margaret Clancy, both went to a jury trial. Prosecutors presented the surveillance footage of Garcia fleeing with the drugs, the audio of Mendez directing him out the back, the phone records proving she called her husband before emergency services, the forensic evidence confirming the drug exposure in all 4 children, and the 20,000 deleted text messages. On November 21st, 2025, both were found guilty of second-degree murder. Garcia received his federal sentence on October 16, 2024. 45 years in prison, plus 5 years of supervised release. Mendez received the same 45-year federal sentence on March 3, 2025. The following day, March 4, 2026, both were sentenced in state court to 25 years to life, running concurrently with the federal terms. As of March 2026, both Gray Mendez and Felix Herrera Garcia are incarcerated, serving concurrent federal and state sentences. No appeals have been reported. Co-defendant Reni Antonio Parra Paredes pleaded guilty in May of 2024, though his sentencing status has not been confirmed. Acevedo Brito pleaded not guilty, and his federal case remains unresolved. The Mendez case became a national flashpoint about childcare oversight. But the truth is, no amount of regulation can account for someone willing to turn a nursery into a drug warehouse. And yet, what happened in that Bronx daycare was not the only time a person entrusted with children's lives chose to end one instead. Tommy Carranza Ladri. The child had only been walking for 4 days. His parents dropped him off that morning at Mignon et Dragon, a licensed home daycare in L'Assomption, Quebec, a small community northeast of Montreal in the Lanaudière region. He was healthy and happy. By that evening, he was gone. On December 4th, 2023, something happened inside that home while Tommy Carranza Ladri, 34 years old at the time and a resident of nearby Notre-Dame-des-Lourdes, was the sole adult present. At some point during the day, Carranza Ladri admitted to shaking the child for several seconds by the base of the neck and then striking him violently. The child's mother then received a phone call from Carranza Ladri claiming the boy had fallen off a toy truck outdoors. When she arrived, she could see immediately that no fall from a toy had done this. The child's head, she would later tell investigators, was completely deformed. The child was rushed to the hospital, where doctors fought to save him. Life support was removed later that evening. He passed away in his mother's arms. The autopsy told a story that no accident could explain. Bruising on both sides of the head, multiple skull fractures, hemorrhaging of the optical nerves. A forensic pathologist would later compare the severity of these injuries to those sustained in a high-speed car collision. This child had not fallen off anything. The force required to produce these fractures was immense, deliberate, and sustained. Carranza Ladri was arrested 4 days later, on December 8th, by the Sûreté du Québec. He appeared in a Montreal courtroom the following day and was charged with second-degree murder. In the days following the arrest, the full picture of what happened inside that home began to emerge through his own admissions. He told his ex-girlfriend that he had thrown the child and struck him in the stomach. He told his half-sister, July Fournier, plainly and without hesitation, that he had done it, that he had taken the boy's life. He gave investigators 11 different versions of events, each one contradicting the last. And through all of it, one fact remained constant. He never called 911. He never administered first aid. He stood in that home with an injured child and chose to construct a lie instead. Would any version of this story have been different if someone else had been in that room? The trial began in January of 2026 at the Palais de Justice de Joliette. It lasted 4 weeks. Quebec Superior Court Justice Marc-André Blanchard presided. Crown Prosecutor Sarah Baudry Leclerc presented the confession, the statements to family members, the autopsy findings, the 11 contradictory accounts, and the testimony of first responders who arrived to find a child with injuries no toddler could survive. The defense, led by Clara Daviau, argued that Carranza Ladri had been in an impaired mental state brought on by alcohol, sleep deprivation, and anxiety. Psychiatrist Dr. Marie-Frédérique Allard testified in support of this claim, but the Crown systematically challenged the expert's credibility and methodology. The jury had to weigh whether impairment could reduce culpability in a case where the defendant admitted to the act, but offered 11 different stories about how it happened. After 2.5 days of deliberation, on February 8, 2026, the jury returned a guilty verdict for second-degree murder, rejecting the lesser option of manslaughter. In early March of 2026, Justice Blanchard handed down the sentence: life in prison, with no eligibility for parole for 14 years. The Crown had requested 15. The defense had argued for 12. The legal minimum in Canada is 10. In delivering his decision, the judge described the crime as an abomination and one of the worst horrors imaginable. Citing the extreme vulnerability of the victim and the repeated lies told in the aftermath as aggravating factors that warranted a term above the minimum. As of March 2026, Tomi Carranza Ladry is incarcerated and serving a life sentence. Parole eligibility falls around 2037 or 2038. No appeal has been reported. What happened in that Quebec home was the act of one person losing control in a single afternoon. But the next case is something different entirely. It is a story of calculated, methodical harm carried out over the course of 2 decades. Ashley Griffith. For nearly 20 years, parents across Australia dropped their children off at daycare centers and trusted they were safe. In cities across Queensland and New South Wales, at more than a dozen licensed childcare facilities, a man named Ashley Paul Griffith was building a career in early childhood education. He rose through the ranks, became a center director, and was well-liked and well-reviewed, with broad access to the children in his care. Between January 2003 and August 2022, Griffith was later found to have repeatedly engaged in serious misconduct involving young girls at multiple facilities where he worked. Much of this was recorded. He also shared material online under the username Zimble, leaving comments that drew further concern. He used distractions during these incidents and showed a lack of regard for those who resisted. He organized the material into collections and compilations, carrying this out across multiple cities, employers, and states, including a period at a facility in Pisa, Italy, between 2013 and 2014. In 2014, Queensland Police's Task Force Argos discovered material uploaded by the Zimble account on the dark web. Officers began the painstaking work of examining thousands of files for any detail that could identify the offender or the location. The recorded sessions often lasted 20 to 30 minutes each. There were thousands of them. The process of tracing the offender took 8 years. The breakthrough finally came when digital forensic specialists identified a patterned bedsheet visible in one image and traced it back to a specific childcare center in Brisbane. In August of 2022, Australian Federal Police raided Griffith's home on the Gold Coast and recovered over 4,000 images and videos from his devices. He was initially charged with 1,623 offenses against 91 children. Hundreds of charges were later consolidated as prosecutors narrowed the scope for trial. How did one man operate across more than a dozen facilities in 2 countries for nearly 2 decades without a single institution stopping him? On September 2nd, 2024, Griffith appeared in Brisbane District Court before Judge Anthony Rafter and pleaded guilty to all 307 remaining charges involving 69 victims. The charges included 28 counts of rape, 190 counts of indecent treatment, 67 counts of producing exploitation material, and 15 counts of repeated conduct against a child. The reading of the charges alone took over 2 hours. Sentencing took place over 2 days in late November of 2024 before Judge Paul Smith. A court-ordered psychiatric evaluation diagnosed Griffith with pedophilic disorder and assessed him as presenting a high level of deviance with no meaningful empathy for his victims. The evaluation noted he had refined his methods over time, growing more calculated with each facility he worked in. Judge Smith sentenced him to life imprisonment with a non-parole period of 27 years. Griffith will not be eligible to apply for parole until 2049. when he will be 71 years old. It remains one of the longest non-parole periods ever imposed in Queensland. As of early 2025, Griffith is incarcerated at Woolston Correctional Centre, a high-security facility in Brisbane, housed in the Sex Offender Management Section under protective custody after another prisoner threw scalding water in his face. On December 20th, 2024, Griffith filed an appeal through his legal representatives at Gnech and Associates, arguing his sentence was manifestly excessive. No hearing date has been set. Queensland Premier David Crisafulli publicly called the appeal horrendous. Griffith also faces an outstanding arrest warrant in New South Wales for approximately 180 additional charges involving 23 alleged victims. Those proceedings are expected to move forward after the Queensland case concludes. A subsequent review by the Queensland Child Death Review Board found that Griffith could have been identified and stopped on at least 5 separate occasions across 18 points of potential detection. None of them caught him. Griffith's case exposed a catastrophic failure of institutional safeguarding across an entire country. But sometimes the system does catch someone, not through years of forensic investigation, but through a single routine check at the right moment. If you want to stay informed when we cover cases like these, consider subscribing. We drop new cases every week, and you don't want to miss the next one. Heather Kuhn. In September of 2013, Lorain County Sheriff's deputies in Ohio conducted a routine compliance check on James Osborne, a registered sex offender. He was supposed to be living at his registered address. Instead, they found him at the home of his fiancée, a woman named Heather Kuhn, in Oberlin, Ohio. It was a probation violation, straightforward enough. Osborne was already a convicted offender, already on the registry, already supposed to be under supervision. But when officers searched the residence, they found Osborne's laptop and phone. On those devices were videos and images of Kuhn carrying out abuse against children at ABC Kids Childcare, a daycare center on North Abbey Road in Elyria, where she had been employed since August of 2012. The abuse had taken place in March and April of 2013, during normal operating hours, inside a facility where parents believed their children were being safely cared for. The records showed Kuhn involved in serious misconduct concerning young children at the facility, documenting the incidents and sharing the material with Osborne. 6 children were affected, and 4 were named in formal charges. All of them were very young and under the care of a licensed facility their families trusted. After leaving ABC Kids, Kuhn moved to another facility, Country Day School in Amherst, where further inappropriate material involving children was later discovered. The behavior had not stopped when she changed employers. It had continued in a different location. Osborne had directed much of this from outside the daycare. Kuhn later claimed she had acted entirely under his influence, saying she had been manipulated and controlled. However, the material suggested a level of active involvement rather than reluctance. Nothing in it clearly indicated hesitation or pressure. She carried out these actions during the regular workday in a building full of children and later shared the material. Did anyone at that daycare, any co-worker, parent, or supervisor, ever notice something was wrong? Kuhn was arrested and initially pleaded not guilty in October of 2013. Her bond was set at $2 million. The case spent nearly 3 years moving through Lorain County Common Pleas Court, a delay caused in part by the volume of evidence and the severity of the charges. Just days before a scheduled trial, on July 1st, 2016, Kuhn changed her plea to guilty before Judge James Maraldi. She admitted to 4 counts of rape, 4 counts of kidnapping, 4 counts of pandering obscenity involving a minor, 3 counts of illegal use of a minor in nudity-oriented material, one count of tampering with evidence, and one count of engaging in a pattern of corrupt activity. The full scope of what she admitted to that day took considerable time to read into the record. A hearing on November 17, 2016, formally designated Kuhn a sexually violent predator under Ohio law, a classification that carries lifetime reporting requirements and community notification. Her defense attorney, Daniel Whiteman, argued at sentencing that she had been under the psychological influence and control of Osborne, comparing her situation to that of a battered partner. Parents of the victims addressed the court directly. They did not accept that framing. They called her a monster. On November 29, 2016, Judge Maraldi sentenced Heather Kuhn to life in prison without the possibility of parole. James Osborne had been sentenced the previous month to the same term. Both were designated sexually violent predators. Both will spend the rest of their lives behind bars. Kuhn filed an appeal, which was heard by the 9th District Court of Appeals. The court issued its decision on May 29, 2018, affirming the conviction on all counts. She remains incarcerated in the Ohio prison system, serving life without parole. No further post-conviction proceedings have been identified. Kuhn's case was discovered because of a routine address check on someone else entirely. A single procedural step uncovered something that might otherwise have continued indefinitely. But in the next case, it was the opposite. There were warning signs. There were inconsistencies in the story from the very first hour. And still, a child's injuries were explained away until it was too late. Thelma Lowry. On October 24, 2014, a toddler was dropped off in good health at Lowry's Little Angels, a home daycare on Ward Basin Road in Milton, Florida, in Santa Rosa County. His parents, Ashley and Mike Kent, had no reason to believe anything was wrong. The child was in normal spirits that morning. By the end of that day, he had sustained injuries so severe that emergency surgeons had to remove a portion of his skull to relieve the swelling in his brain. The swelling was so extreme that the surgical opening could not be closed. 5 days later, on October 29th, the child passed away at Sacred Heart Hospital in Pensacola. Thelma Lowry, the daycare's operator, told first responders that the boy had been struck by a wooden block thrown by another child in her care. It was a simple accident, she said. But the injuries did not match that explanation, and they never would. Doctors found multi-layer hemorrhages in both eyes, a blood clot and active bleeding inside the brain, and bruising spread across the child's body and head. The pattern was consistent with shaken baby syndrome and non-accidental blunt force trauma. A retinal specialist noted the hemorrhaging was present across multiple layers of both eyes, a finding that does not result from a toy striking a child. And then the autopsy uncovered something even more troubling. A chronic membrane was present in the brain, evidence of a separate, earlier bleeding event that had occurred 1 to 2 weeks before the fatal incident. This child had been harmed before, and the earlier injury had gone undetected. Lowry made statements to multiple people in the hours after the injury, expressing concern that she would be blamed for what happened to the child. She made these statements before any evidence of non-accidental trauma had been publicly identified, before doctors had even completed their assessments. She also claimed she had bathed the boy before the ambulance arrived. But first responders found dry vomit still in the child's hair, contradicting her account from the very beginning. Was there ever a version of this story where the wooden block explanation held up under any scrutiny at all? Lowry was initially arrested in October of 2014 and charged with aggravated child abuse. She was held without bond. State Attorney Bill Edens oversaw the case. A grand jury convened on November 12th and upgraded the indictment to first-degree felony murder in the commission of aggravated child abuse under Florida statutes. Her daycare license was revoked by the Florida Department of Children and Families. The trial began the week of August 7, 2017, before Judge Kelvin C. Wells in Santa Rosa County Circuit Court. Prosecutor Greg Marcil called a series of medical experts to the stand. Dr. R.F. Rifai, a retina specialist, testified about the multi-layer hemorrhages in both eyes, explaining in detail why such injuries cannot result from a minor impact or fall. Dr. Matthew Pearson, a pediatric neurosurgeon, described the catastrophic brain swelling and the emergency surgery that failed to save the child's life. The medical examiner detailed the chronic membrane, which pointed to abuse predating the fatal incident by 1 to 2 weeks, meaning this had happened before and no one had known. A Williams Rule witness testified that Lowry had been observed handling the child roughly on previous occasions, establishing a pattern of behavior. Lowry's inconsistent statements were presented as evidence of consciousness of guilt. She had told too many versions of the story, and none of them matched the medical evidence. The defense team, led by Tony Henderson and Lori Raybon, argued that an undiagnosed pre-existing brain condition could have caused or contributed to the injuries. The prosecution countered that no such condition was found during autopsy and that the injuries were entirely consistent with inflicted trauma. Under Florida's felony murder statute, the prosecution did not need to prove intent. They needed only to establish that the child's death occurred during the commission of aggravated child abuse. After approximately 5 hours of deliberation, the jury returned a guilty verdict on August 11, 2017. Thelma Lowry was sentenced immediately to life in prison without the possibility of parole, the mandatory sentence for first-degree felony murder in the state of Florida. She was 58 years old. Lowry filed an appeal with the Florida First District Court of Appeal. On June 20, 2019, the court affirmed the conviction. Judge Wolf authored the opinion, with Judges McCarr and M.K. Thomas concurring. Lowry had raised 6 issues on appeal. The court found none of them had merit. As of 2026, Thelma Denise Lowry is serving life without parole in the Florida Department of Corrections. No further post-conviction proceedings have been identified. Yoselin Ortega. On October 25, 2012, Marina Krim brought her youngest daughter, Nessie, to a swimming lesson at the YMCA on the Upper West Side of Manhattan. Her other 2 children, Lucia and Leo, stayed home with the family's nanny, a woman named Yoselin Ortega, who had been with the family for approximately 2 years and earned $18 an hour. Ortega was supposed to take Lucia to ballet class that afternoon. She never showed up. When Marina returned to the family's apartment at the La Rochelle building on 75th Street near Columbus Avenue to find out why, the apartment was dark and quiet. She found both of her children in the bathtub. Lucia had been stabbed more than 30 times. Leo had been stabbed 5 times. Both had been fatally harmed. Ortega was on the bathroom floor beside them with self-inflicted wounds to her wrists and throat. She survived. Kevin Krim, the children's father and a CNBC executive at the time, was away on a business trip. Police intercepted him at JFK Airport before he could arrive home. The investigation into Ortega's motive revealed a woman struggling with financial pressures and resentment. Prosecutors argued she was jealous of Marina Krim's life, frustrated over her own money problems, and upset that her hours had recently been reduced. Her family had fabricated her references before she was hired. A family friend had sent a false recommendation letter. Ortega had been struggling with depression and anxiety, but had refused medication. Her family never disclosed any of this to the Krims. What happens when the person you trust most with your children is the one you should have feared? The path from arrest to trial was extraordinarily slow. More than 90 pre-trial court appearances stretched across 5 years. Jury selection finally began on February 22, 2018, and opening statements followed on March 1st. The trial took place in Manhattan Supreme Court before Judge Gregory Caro. Prosecutors Stuart Silberg and Courtney Groves, working under Manhattan District Attorney Cyrus R. Vance, Jr., presented the case for the state. Defense attorney Valerie Van Leer Greenberg mounted an insanity defense. Ortega conceded through counsel that she had taken the children's lives, but claimed she had been in a state of severe psychosis and dissociation, hearing the voice of the devil. The prosecution argued she understood every act she committed that afternoon. In April of 2016, roughly 2 years before the trial began, Judge Caro had offered Ortega a plea deal of 30 years to life over the prosecution's objection. Ortega rejected it. On April 18, 2018, the jury found Ortega guilty on all 4 counts: 2 counts of first-degree murder and 2 counts of second-degree murder. Sentencing followed on May 14th. Judge Caro called Ortega pure evil. Marina Krim addressed the court and said that Ortega may have believed she destroyed Lucia and Leo, but she failed in that too. Kevin Krim described her as a dangerous narcissist who deserved to live and rot and die in a cage. Ortega was sentenced to life in prison without the possibility of parole on the 2 first-degree murder counts, with consecutive terms of 25 years to life on each of the 2 second-degree counts. She appealed. The appellate division dismissed the 2 second-degree murder counts as redundant, but otherwise affirmed the conviction. The New York Court of Appeals reviewed the case in 2023 and found that the admission of an autopsy report had technically violated Ortega's confrontation rights, but concluded the error was harmless beyond a reasonable doubt, given the overwhelming evidence and the fact that the defense had never disputed the cause of death. The conviction was affirmed. All state appeals are now exhausted. As of 2026, Yoselin Ortega is serving life without parole in New York State Prison. The Krim family founded the Lulu and Leo Fund and Choose Creativity, nonprofit organizations that provide creative education opportunities for disadvantaged children. Ortega's case was defined by the slow grind of due process: 5 years of hearings, a rejected plea deal, an insanity defense that the jury did not believe. But not every case takes that long to reach a verdict. Sometimes the violence is so sudden and the evidence so clear that the legal system moves with a different kind of urgency. Kimora Hodges. On June 13, 2022, Taylor Starks dropped her toddler off with a neighbor in an apartment on Little Mac Avenue in Roseville, Michigan, in Macomb County. The neighbor was a woman named Kimora Hodges, who had been babysitting the child on and off for about 2 months, while Starks worked at a restaurant in nearby East Point. Hodges was not a licensed daycare worker. She was not employed by any facility. She was an informal caregiver, a neighbor who had offered to help. And until that day, there had been no reason to question the arrangement. That afternoon, Hodges sent text messages to the mother complaining about the child's behavior. She called him sneaky and said the mother was too soft on him. The messages were pointed and frustrated, but nothing in them suggested what was about to happen. Roughly 5 hours after those initial texts, she sent a photograph showing visible swelling around the child's eye. Hodges told the mother the child had eaten soap and was having an allergic reaction. When Starks rushed home, she found her son on the ground, having seizures, twitching, and completely unresponsive. He was bleeding from his ears. He was rushed to the hospital, where doctors found subdural hemorrhage, bilateral retinal hemorrhages, and severe blunt force trauma to the head. The brain swelling was so extreme that emergency surgery was required, but there was no brain activity. The damage was catastrophic and irreversible. The child was placed on life support. 8 days later, on approximately June 22nd, he was gone. After her arrest, Hodges admitted to the abuse. She told investigators that maybe she hit him too hard, but insisted she had not taken her anger out on him. The medical evidence told a different story entirely. The injuries were consistent with being beaten and thrown against a wall with significant force. This was not a moment of lost patience. This was sustained violence against a child who could not defend himself and who weighed a fraction of what his attacker did. If she knew she had hit him too hard, why did she send the mother a photograph blaming soap? Hodges was charged with first-degree child abuse, and after the child's passing, the charges were upgraded to first-degree felony murder. The case moved through significant pretrial delays. Hodges filed an interlocutory appeal challenging the admissibility of statements she had made to police. The Michigan Court of Appeals ruled on May 30th, 2024, in case number 368197, ordering one statement suppressed and one admitted. The case was then remanded for trial. A 6-day jury trial proceeded before Judge Diane M. Druzinski in Macomb County Circuit Court. Prosecutors Mark Laws and Lisa Lozen presented the medical evidence, the text messages, the photograph of the swelling, and Hodges' own admissions. Defense attorney Marielle Lehman argued on her behalf, but the evidence was extensive, and the timeline left little room for alternative explanations. On July 31st, 2025, after approximately 2 hours of deliberation, the jury returned a guilty verdict on all counts. On November 4th, 2025, Kimora Hodges was sentenced to life in prison without parole for felony murder, with an additional 15 to 40 years for first-degree child abuse. Macomb County Prosecutor Peter J. Lucido issued a public statement emphasizing the severity of the sentence and the brutality of the crime. As of 2026, Hodges is incarcerated, serving life without parole. A post-conviction appeal has been filed at the Michigan Court of Appeals under case number 378509 and remains pending. Hodges was not a licensed professional. She was not employed by a facility. She was a neighbor who agreed to watch a child, and in the span of a single afternoon, she took everything from a family that had trusted her. But the same is true of the next case, where another informal babysitter, another trusted neighbor, lost control and then tried to blame the evidence on everyone but herself. Lindsay Parton. In early March of 2018, Jason Wesche trusted his neighbor, Lindsay Parton, to babysit his toddler daughter Hannah at her home on Shank Road in Hanover Township, Butler County, Ohio. Parton was not a licensed daycare operator. She was a neighbor who had been watching the child for several months and was considered a reliable, familiar presence in the family's life. On March 8th, Hannah was brought to Parton's home. Within minutes of arriving, she collapsed and became unresponsive. She was rushed to Cincinnati Children's Hospital with traumatic brain injury, cervical spinal cord hemorrhage, optic nerve sheath hemorrhages, and extensive bruising across her face, ear, chest, and neck. She fought for 10 days on life support. On March 18, 2018, Hannah passed away. She was a toddler. During the investigation, Parton told detectives that she had slapped the child on the side of the face, struck her with a fist in what she described as a knuckle uppercut to the chin, poked her in the chest with a rigid finger, squeezed her tightly around the belly, and violently shaken her. She said the abuse escalated after the child dumped ketchup in a toilet. Prosecutors also noted that Parton had recently suffered a miscarriage and may have been in a volatile emotional state at the time. Additionally, investigators discovered that Parton had searched online for how to get rid of bruising in the days surrounding the abuse. A search that suggested awareness that visible harm had been inflicted. The injuries were not the result of a single moment of lost composure. Medical evidence indicated a pattern of escalating harm across March 6th through 8th, meaning the abuse had been ongoing for days before the child's collapse. At what point does a person stop and realize that what they are doing to a child cannot be undone? An 8-day jury trial took place in April of 2019 before Judge Greg Stevens in Butler County Common Pleas Court, case number CR 2018-03-0462. Prosecutors Lindsay Sheehan and Kelly Haley, working under prosecutor Michael T. Gumoser, presented the medical testimony, the confession, and the internet search history. The defense, led by Melinda Cook Howard, argued that the injuries could have been caused by accidental falls or by the father. At trial, Parton recanted her confession entirely, claiming she had been pressured and coerced by detectives during questioning. But medical experts testified that the child would not have been able to function normally after sustaining the fatal brain injury, which directly contradicted the defense's proposed timeline, suggesting the harm occurred before the child arrived at Parton's home. The jury was not persuaded by the retraction. After approximately 12 hours of deliberation, they found Parton guilty of murder, involuntary manslaughter, and 4 felony counts of endangering children. On May 9th, 2019, Judge Stevens sentenced Lindsay Parton to life in prison with the possibility of parole after 15 years for the murder conviction, plus 3 consecutive years for child endangering. The total sentence amounted to life with parole eligibility after 18 years, the maximum the court could impose. She was also required to register as a violent offender under Sierra's law, Ohio's Violent Offender Registry. Parole eligibility falls around 2037. Parton appealed. The 12th District Court of Appeals affirmed the conviction on September 28, 2020, in an opinion authored by Judge Robert Ringland. Parton then sought review from the Ohio Supreme Court. On January 22, 2021, the court declined to hear the case. All state appeals are exhausted. As of 2026, Lindsay Parton is incarcerated in Ohio, serving a life sentence. Her case was later featured on the television program Court Cam Presents Under Oath. Parton confessed, then took it back. The jury did not believe the retraction. But in the next case, there was no confession to retract. There was surveillance footage, dozens of incidents captured on camera, and a pattern of behavior so deliberate that even the sentencing judge struggled to reconcile it with the possibility of the defendant ever being released. DeJoyne Ferguson. On September 5, 2019, at approximately 10:35 in the morning, an infant named Isabella Rosetta Talton stopped breathing inside the Little People Child Development Center on Wrangle Hill Road in Bear, Delaware. DeJoyne Ferguson, an 18-year-old employee who had been working in the infant room, was the last person to handle the child. She had placed her hands over the baby's mouth and nose for more than 3 minutes while wearing latex gloves. Video surveillance captured the entire act. The child became motionless and unresponsive. Ferguson then placed her back in a crib and waited approximately 20 minutes before telling the facility's owner, who called 911. Isabella was transported to Christiana Hospital and pronounced dead. She was 4 months old, but Isabella's passing was not the beginning of this story. It was the end of a pattern that had been going on for months. When investigators reviewed the daycare's surveillance footage, they discovered that Ferguson had been systematically smothering children in her care on 28 separate days between June or July and September of 2019. Multiple children, multiple incidents per day in some cases. On at least 2 occasions, She suffocated a child until the child lost consciousness, waited for the child to revive, and then covered the child's face again. Ferguson later told a forensic psychologist that she felt more relaxed after the fatal incident because she'd been able to release her anger. She told police that she had changed her method of suffocation over time to make it more effective, progressing from one hand to two hands, extending the duration, and switching to latex gloves so she would not get saliva on her skin. How does a person refine a technique for harming infants and then describe the process to investigators as though it were a job skill? Ferguson had been hired in January of 2019 when she was 18. After roughly 2 months, the lead teacher in the infant room was terminated, and Ferguson was left to manage the room largely on her own, with minimal training or supervision. She later admitted she was completely overwhelmed. The daycare had passed a state inspection in May of 2019 and held a 5-star rating at the time of Isabella's passing. She was initially charged on September 6, 2019, with 1 count of first-degree murder. A grand jury indictment on July 13, 2020, expanded the charges to 53 felonies involving 5 child victims. 1 count of murder by abuse or neglect in the first degree, 48 counts of first-degree child abuse, and 4 counts of second-degree child abuse. Bail was set at $1 million cash. Deputy Attorneys General James Creener and Diana Dunn of the Special Victims Unit prosecuted under Attorney General Kathy Jennings. The case did not go to trial. On April 14, 2021, Ferguson pleaded guilty to 1 count of murder by abuse or neglect, 6 counts of first-degree child abuse, and 2 counts of second-degree child abuse. The remaining charges were dropped as part of the agreement. On June 25, 2021, Ferguson was sentenced to life in prison for the murder count, plus additional terms on the abuse counts. The maximum possible sentence had been life, plus 154 years. Prosecutors had recommended 65 years. The sentencing judge described the case as shocking not only in its brutality, but in the profound violation of trust that parents had placed in the hands of a caregiver they had no choice but to rely on. The judge stated plainly that the idea of Ferguson's eventual release could not be reconciled with the act of smothering a 4-month-old to death. Ferguson appealed, arguing the judge had sentenced her with a closed mind for the sole purpose of retribution. The Delaware Supreme Court affirmed the life sentence on August 5, 2022, in an opinion by Justice James Vaughn, Jr., concluding the judge had considered all mitigating evidence and simply was not persuaded by it. As of 2026, DeJoyne Ferguson is serving life in prison at Baylor Women's Correctional Institution in Delaware. The parents of Isabella Talton filed a wrongful death civil lawsuit against the daycare on May 4, 2020. Ferguson's case was captured on camera from beginning to end. The surveillance footage left no room for ambiguity or alternative explanations. But the final case on this list had no such clarity. It has been fought through the courts for 15 years, overturned twice, and as of today, it is still not fully resolved. Maria Owens. On June 1, 2011, a toddler named Jalen Kelly was dropped off at the home of Maria Owens in Fairburn, Georgia, in Fulton County. Owens ran an unlicensed daycare out of her residence. Jalen was 3 days short of his first birthday. His older sibling was also in Owens' care that day. That morning, the children's parents had told Owens something she did not want to hear. They were planning to move their children to a more structured daycare environment. The children were Owens' only source of income, and she was in the middle of a divorce. Approximately 1 hour after learning the family's decision, Owens called 911 and reported that Jalen was not breathing. The child was airlifted to Children's Healthcare of Atlanta at Eagleston. He did not survive. The autopsy revealed a fractured back and a loss of nearly half his total blood volume. Fulton County District Attorney Paul Howard stated that the child's body had been slammed down into either the side of a bathtub or onto a hard floor. The medical examiner concluded that an immense amount of force would have been necessary to fracture the child's spine. Owens admitted to striking the baby, but claimed she had only been trying to help him cough to clear symptoms of bronchitis. If the only thing that changed in that house between the morning drop-off and the 911 call was a conversation about losing income, what does that tell us about what happened in between? Owens was charged with 2 counts of felony murder, aggravated assault, first-degree cruelty to children, and felony involuntary manslaughter. What followed was one of the most complicated legal journeys in any case on this list. The first trial took place in 2013 before Fulton County Superior Court Judge Henry Newkirk. Owens was convicted of felony murder and involuntary manslaughter, but Judge Newkirk then vacated the felony murder conviction, citing a Georgia legal provision that made those 2 verdicts mutually exclusive when based on the same act. She was sentenced to 10 years on the manslaughter count. In 2014, the Georgia Supreme Court reversed all of the convictions, ruling that guilty verdicts for crimes with fundamentally different mental states, intent versus negligence, cannot coexist when they stem from a single act against a single victim. A new trial was ordered. Then, in 2015, the Georgia Supreme Court overruled its own precedent from the Owens case in a separate decision called Springer versus State, holding that such verdicts are not categorically mutually exclusive after all. The legal landscape had shifted, and Owens' case was sent back for a second trial under the new standard. The second trial took place in 2020, again before Judge Newkirk. This time, Owens was convicted of murder, felony murder, aggravated assault, and first-degree cruelty to children. She was sentenced to life in prison in January of 2020. Under Georgia law, parole eligibility on a life sentence requires a minimum of 30 years served. But in February of 2026, the Georgia Supreme Court intervened again. In a decision authored by Justice Charlie Bethel, the court reversed the felony murder conviction for the second time, finding that the trial court had given the jury flawed instructions. The judge had told jurors they could not find Owens guilty of both involuntary manslaughter and aggravated assault, applying the old rule from 2014 that the court itself had already overruled. Justice Bethel wrote that the court had previously used a sledgehammer and done so incorrectly, and was now attempting a more precise approach. The child cruelty conviction was left standing, but its sentence was vacated pending further proceedings. A partial dissent by Justice Carla Wong McMillian argued that all affected convictions should have been reversed. As of March 2026, Owens's felony murder conviction has been overturned for the second time. The child cruelty conviction remains intact. Fulton County prosecutors must now decide whether to retry her on the felony murder charge, which would be her third trial. Her incarceration status is unclear pending the prosecution's decision. She had been serving a life sentence since January of 2020. No announcement regarding a potential retrial has been made public. Thanks for watching. If you want to see more cases like these, subscribe. We cover stories like this every week. And if you want to keep going right now, click the video on screen. It is worth your time. See you in the next one.